So, the victims who are the police officers and all disciplined officers in this country, if they were not excluded from Article 37 of the Constitution to go picketing and demonstrating, by now, all police officers could be on strike. But we stopped them and told them Article 37 is not theirs. They are coming to you because that is the only avenue available. But don't release the accused person. You're on a fourth. The accused person, if released through the Oscar Sudi decision by Justice Ngugi, Professor, but the police must continue providing security. Show me the practicability. If you release this person, if these police officers will stop the public from lynching him. Police will not. Instead, they will be ready to come and pick a body. It is therefore for his safety and for the safety of an accused person relies on the court.
Your Honor, that is with due respect to my colleague.
You will object.
I'm objecting. Your Honor, you gave parameters, and we are okay with the incitement that he's doing because it's on behalf of the victim. But when it comes to the point of now telling us that what will happen to the accused person, unless he has been given those instructions by his client, who he says is so ill, cannot even sign an affidavit, he's going outside your guidelines. I don't think that would be right.
Yeah, and that's why Your Honor.
I mean, what my learned colleague has said, he has said that these policemen are not really protected.
Yes.
And initially, he had said that they are not on strike. He is confirming that National Police Service and Article 44 are on strike insofar as that young man is concerned, which is very prejudicial. And this court cannot entertain such submissions from an advocate holding brief for the complainant, regardless of how emotive the matter is. This is a court of law. Someone cannot come here and say that the policeman that this young man pays through his taxes cannot protect him. That is wrong, and Mr. Omari should recant that.
Your Honor, additionally, I thought your guidance, whether Mr. Omari's submissions should go outside the scope of paragraph 8,
It's about the victim.
Paragraph E. If he would limit himself to that paragraph, this halubaloos that he's submitting on would not be in a position. You know, when he says that the young man cannot be protected by the police, and then you are being told, don't release him, will you go with him to your house? Will he not go with him? Will he not be taken to prison should you decline to grant bail? Are those not police officers? Where is the young man safe? Then unless Mr. Omari takes him with him to his house.
Your Honor, just before Mr. Omari proceeds, you have given parameters now which an advocate watching brief can proceed, Your Honor. It will be good for this court to stamp its authority.
Yes.
It is for such submissions, Your Honor, that the Supreme Court limited the role played by the advocate watching brief. He may be free to submit about the father-in-law, the mother-in-law, the cousin of this, of the police officer. But he should not be permitted, Your Honor, to purport to be speaking for the accused person who is ably represented. Do not mourn more than the bereaved. Do not wail louder than the owners of the funeral. We have our time.
And I think I've not gone outside the parameters. The victims. I'm talking on behalf of the victim, not the DPP.
How many victims are here? The family, the police?
Father-in-law.
The father-in-law. How many victims are here?
I have said in this matter, all disciplined officers are victims. All of them.
Your Honor,
No, 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 no.
Your Honor, that is where you need to draw the line.
And we need to then elaborate.
The charge sheet is very clear. The national, Mr. Javere Koome is not a complainant. And my learned junior here is saying that the entire police service, or the entire, I don't know what, he must show us. And he has the charge sheet. Let him read that the entire police service is a complainant. He is only actually trying to poison the mind of this court by trying to show as if this world is coming to an end because a policeman has been alleged to have been assaulted by a citizen. Well, they're even invoking American jurisdiction, where we saw direct shooting, killing a demonstrator in the streets of America. That's the type of things that Mr. Omari is opening a Pandora's box because he's excited of the media. Kindly let my learned junior restrict himself. Restrict himself.
Mr. Omari, don't be superfluous in your scope is limited.
Alright.
Now you're trying to shift to the accused, yeah? You're saying if the accused is released, I think that is beyond you.
Alright.
Yeah. So just limit yourself because I granted you because I think a victim plays a very integral role.
Alright.
And very limited ones.
Or of course limited.
Alright.
Yeah.
Alright.
So maybe you should be...
You know, I've been told I'm junior. And I admit that.
That is by the president of the
I
Advocates Act.
accept.
That is not in contention. Mr.
That's
Omari.
not in contention. I'm the junior most advocate. But listen to that junior most advocate. Does he give what matters? It is not when you signed the roll. It is what comes out of that brain. You know, why I'm raising this issue, charge account number 1. It's robbery with violence. And the particulars are that with others not before court robbed Job Ogendo of the battery of police communication gadget and a mobile phone. The import of a police communication gadget in the possession of an accused person is a grave national security issue. That is the person you are being told to release. And I urge the court to take judicial notice that police communication gadgets are a serious tool for the preserve of the police.
Again, Your Honor, we object to that line of argument.
Could I get a checklist to what they want me to talk?
Because
they're objecting to everything.
He's now going to
Let them...
that are out of his control.
That of evidential in nature.
The is very clear where you are supposed to confine yourself.
Your Honor,
we have not even
this
been
communication
with the
gadget was in the hands of the victim, my client.
So you know those allegations?
Yes.
So let's not, it's a fact, it's a factual matter.
Perhaps to manage, as Your Honor, you could give us indication of time.
Let me give...
If you give Omari perhaps 2 minutes, he may be more
I have
relevant
only 1 more
than what
minute
he
to
is.
go.
Alright, let's give him the 1 minute.
I have only 1 more minute to go. You know, the victims cry that before the court renders itself on the suitability of the accused being granted bail or denied bail, the court orders for a pre-bail report to bring to the attention of the court the actual circumstances within the community, within the family, so that the court will arrive at a fair and just decision to deny or to grant. But on behalf of the family, on behalf of the complainant, we completely object for the accused to be released on bail and his prayer is that he be allowed to testify. If the court will be inclined to grant bail or bond after he has testified, given his version before this court. That's all.
All right, thank you, Mr. Omari. Now, that concludes the first team of the DPP and the...
Yes, Your Honor, we will be submitting that we will take very limited time because we will really wish the court to make a decision today in this matter. And I know the issue of time is an issue. Your Honor, first of all, we submitted extensively yesterday and took a lot of your time. In persuading you, Your Honor, to find it fit to admit the accused person to reasonable bond, terms or cash bail options. So, Your Honor, I would want to adopt, and that is the position of the defense, the submissions we made yesterday, mutatis mutandis, as our submissions today. But over and above that, Your Honor, based on the affidavit that has been brought before you, Your Honor, we will demonstrate that in this affidavit, Your Honor, it is the prosecution itself, as opposed to the victim or the investigating officer, that is perpetrating these particular reasons that we've been given. Your Honor, the prosecution, and it has made it a habit, I wish J.V. Witty was here, they have made it a habit to actually yell more than the mother in the labor room. They yell the loudest, yet they are outside there taking Coca-Cola. Your Honor, no, that's off the record. That's off.
As we don't talk yet.
Yes. Your Honor, if you look at the reasons that you've been given, first of all, in terms of the legal parameters, Your Honor, we are all in agreement that bond is a constitutional right. We do not need to regurgitate that.
And Mr. Sonko are in connivance.
Objection.
That's judicial notice.
Objection, Your Honor.
Judicial notice. For Mr. Sonko to post things on the social media, for Mr. Ashoka to come and rely on them here,
Your
and
Honor,
say
Mr. Lempa
that
is
these
a very
things...
senior advocate. He should know the rules of the court. Once a counsel rises on his feet, you sit down, please. Your Honor, I do not wish to be dragged into this case as a party. I only brought it to the attention of the court that there are social media postings being done which show that there is interferences of witnesses. And I ask the court to take judicial notice of that. I have no, in fact, I'll not even bother to respond to about Mr. Sonko.
Yes, on judicial notice, Your Honor, we have the charge sheet. It's very clear. All the witnesses therein are police officers. Mr. Ashoka did not lay any basis that Ian Njoroge is likely to interfere with police officers. In fact, it is them who are likely to interfere with his health, as it has been demonstrated. So that when you are constructing section 60 of the Evidence Act, Mr. Ashoka did not lay any basis that that particular posting by Mr. Sonko was posted by agents of the accused person. That's the point I'm driving. And because it is judicial notice and therefore speculative, we can speculate either way, that it has been made by the prosecution, and as Mr. Ashoka was claiming, was posted by ourselves, which we are denying that we have nothing to do with Mr. Sonko in this proceedings.
He made similar submissions. I'm only giving the account of what transpired to indicate to you that the accused person before you is not a flight risk. He confirms to me they went had lunch with his grandmother and his family at about 1 a.m. At 6 p.m. they went back to the house. At 8:30 p.m. the police...
An opportunity to cross-examine counsel. Because those are matters of fact.
Well, I'll proceed. But the court has taken note of the account that he was therein after arrested at 8:30 p.m. while still at his mother's house. That confirms to you, Your Honor, that the accused person before you is not a flight risk. You've been invited to look at the status of the victim, the alleged victim, his age, his time, period of service in the police service. But that has never been a consideration while evaluating the compelling reasons under Article 49. You've been asked to deny him bail on the count of his safety. You've been told that the only place that he can be more safe is with the police. We have allegations that the police have assaulted our client. And
Old student of Sunshine School, currently a first-year student of civil and structural engineering at the Technical University of Kenya. He is a Christian, a member of the university choir and Christian Union. Having introduced the accused person, Your Honor, I'll address you to what the prosecution purports to be compelling reasons. And Your Honor, as I address you, I want to go on record that our guiding document is the Constitution, and that the cardinal consideration when issues of bond and bail are being canvassed is whether the accused person will be able to attend court or not. That is the primary cardinal consideration. The rest are secondary and tertiary considerations. They have not denied that he's a student. What they have said is that his only crime, he ran away to his mother's house. Did they expect a 19-year-old to have a home? He is available. He will attend court dutifully as and when he is required. Your Honor, then the prosecution goes on a trajectory of wailing louder than the bereaved and saying that the accused will be insecure. Your Honor, it is settled law. And I will quote the dictum of Ouko J, as he then was, in Nicholas Kipsigei Ngetich and 2 others versus the Republic. While the prosecution raised such issues, and while frowning at the issues, the court said, it is the duty of the state in terms of Article 29C of the Constitution to ensure the safety of all citizens. He goes further and says, it cannot be in the mouth of a state official, like the prosecution here today, charged with the duty to provide security, to allege that a citizen, for whatever reasons, can be insecure. What they are inviting you, Your Honor, is that as you release Ian, the state is asking you to compel the police to ensure he's safe and secure, to remind them of their cardinal duty. Your Honor, the second issue is the issue of interference of witnesses. We are at pains to submit how a 19-year-old student will interfere with a 57-year-old police officer, and the witnesses lined up by the police force with unlimited state machinery, including tools of violence. In any event, in Republic versus Dwight Sagary and others, High Court case number 61 of 2012, the High Court had this to say: for the prosecution to succeed on the line of witness interference, it must bring before court cogent evidence of either real or perceived interference. Your Honor, whereas counsel are supposed to be well deep into the law, books of law and the Kenya law reports, here is a prosecution that has taken a bit of time on social media and brings you a clip of one Mike Sonko. We do not want to discuss Mike Sonko in this court, but it is embarrassing to the state that the only material placed before you is an alleged conversation of Mike Buvi Sonko with unknown Kenyans without demonstrating their relationship with the accused person. And that is why we strongly believe that it is part of the script by the National Police Service, aided by the prosecution, to concoct videos to come and convene this court that there is witness interference. Refuse that invitation, Your Honor. Your Honor, the prosecution has said that this offense is so serious, and my learned brother Omari has equally dramatized it in a very good manner by saying that when the accused person allegedly attacked the police officer, that he was attacking the crown, that he had his cape on, that the uniform was blue, that he was beating Kenya. Your Honor, the question that we should ask is this: when a police officer take bribes, and there have been convictions of taking bribes, do they take bribes on behalf of the nation and the people of Kenya? When the police officer kills Willie Kimani, are they killing Willie Kimani on behalf of the people of Kenya? Your Honor, the same way the police commit crimes in their personal capacity, when it is alleged that they are beaten, it is individual police officers who are beaten and not the state. Your Honor, we submitted yesterday that the seriousness of the offense cannot be relied on by the state to deny bond. And we gave you the authorities. We do not wish to say more regarding those authorities. Very lastly, Your Honor, the state has demonstrated by way of submissions that even if you released the accused person, the police force will not be willing to protect him. We wish to go on record as advocates of the accused person that what is alleged to have happened was a tragic comedy. It's called a tragicomedy in literature. And the accused person in that play, if they're relying on social media, is the tragic hero for refusing to pay a bribe. He has been dragged to court and is here with us. What will happen if you hand the accused person to the police officers who are in this courtroom in unprecedented numbers? Not even charges of terrorism have attracted such a huge chunk of police officers. What will happen to this accused person? Your Honor, this court has the cardinal primary responsibility of not just ensuring the liberty of the accused person, but also ensuring his security, whether he is in prison or out of prison. And what Odunga said that I must pen off with, Odunga said in the decision that I have given of Nicholas Kipsigei, that it is absurd for the state to imagine that the only safe place for an accused person is prison. That was Odunga J, as he then was, lamenting at the state's submission that prison is safer than home. I rest my case, Your Honor.
Thank you.
Yeah.
And then I'll also call for a prepaid assessment report so that I can get additional information. I think it has been imputed that we are not certain on the residents and whether the accused person is a student. I think that additional information will come through that report. So I think it's very important and critical that we have that report. So I'll keep that report to be filed tomorrow, and then I'll render my ruling at 9 a.m. on Friday.
You know, only one more thing for your directions. May you kindly order where the accused persons will be detained.
So we'll go
Because,
for that.
yeah.
Let's at least now give the direction
Right.
for that.
All
So
right.
now we can go now to the next
Yes.
one.
All right.
Yes.
All right.
Yes, Mr.
Your Honor, let me take it. Your Honor, yesterday you ordered that the accused person be taken to Kenyatta National Hospital. And we had made that application and it was to be done yesterday. Your Honor, we were able to extract the order and we thank the court and the staff. The order was out by 2 p.m. That is yesterday. Your Honor, instead of obeying those orders, the police who we've been told are complainants decided to take the accused person to Industrial Area GK prison, straight, and on the face of the orders. And we had told them that these orders require even the parent to be available. Your Honor, what they did, and I do not want to go deeply into what happened to the accused person on his way, but eventually they've taken him to hospital today. And Your Honor, what the accused person has been told, and is here, is that he has a broken jaw. We can interpret these documents in a, no, Your Honor, it is
Which are meant to
Your Honor, we are not in a in actual the proceedings
unless
actually.
they are off the record, Your Honor.
No, it can't be even off the record because it's quite sensitive.
Yes.
It's very sensitive. So
Yes.
Mr. Carters, you make those amendments.
Yes.
And you be very cautious, yeah?
Your Honor, we have documents. Your Honor,
If it's a broken,
not the hand. This is the documents. Your Honor, there is a report. There are medical reports and
confirms.
yes, that confirms.
Let-
and
Just reading the code.
Let the report be read. unless it's written in Latin.
You do not have a medical report, you have prescriptions.
A report is the only one that can say that.
Your Honor, because you know this is an issue of the health of an accused person. And you know, he is here, he has been told that way. Remember, Your Honor, the parents were denied a chance to accompany. There's a reason you gave that order. And the same people who are complainants have brought these documents and most likely not brought the report. They are the ones who took him. They have. Those are very relax, boss. Your Honor, these people must learn to relax. Your Honor,
the reason
I'm on my.
To them, they are matters of facts. We are being said to have hidden documents from court, pursuant to a court order by a counsel who is an officer of this court. He should substantiate that we have hidden documents.
Your Honor, I will substantiate if he gives me time. Your Honor, we want to save time. Let him relax. Your Honor, we are saying the documents, and if we go to the law, the person who has documents, Your Honor, cannot then benefit out of that because it's not us. They took this person to hospital. The question should be asked. These are prescriptions. You are not being given prescriptions because you are happy it's Christmas. You are being given prescriptions because you are sick. So there must be a report which should be with them. All I'm saying to save the court's time. Yes.
I asked ordering for a report to be filed.
Very well.
Yes.
All these issues of whether
Very well.
you know the kind of
The doctor's file
injuries
report.
he sustained. So I think that's what we can do because I believe we can still be accepted in the same facility with a report in a way.
Yes, Your Honor.
Actually, I'm getting to that, Your Honor. And that is why I was saying the doctors, we have been told, actually released him because he had to come to court. So they have not finished attending to him. All we are requesting, Your Honor, is that he now be taken directly to the same facility, Your Honor, so that they finish attending to him. They will recommend whether he'll be admitted or not. It is up to them. But it is important that you make an order that a report be filed in the language that all of us will understand. Or that doctor be summoned here so that they don't say it is us we are interpreting. In a manner that the court will also have visibility of what the accused person is going through, even at the point that you'll be making a decision. And I think that will also help in terms of the prebail report, because we can actually even know where the accused person will be. And the order that, again, the parent accompany the accused person. Your Honor, we still beg that you retain that order. Your Honor, there is extension of parental responsibility under the Act. No, relax. Your Honor, there is an order that was given. And all we are saying, Your Honor, let that remain. So that at least there is that comfort during the pendency of this, because we are balancing these rights at this particular point. That's all we are asking.
Only one more issue just to add on what Mr. Okacha said, that these medical documents and medical reports, in the absence of a P3 form, will not be complete. So that, Your Honor, we commence the process as should be commenced, because we shall be taking serious actions as against the aggressors. Number two, Your Honor, just to show you the incompleteness of the report, is that one of the documents given to us by the DPP dated the 5th of June is a document from Kenyatta Hospital, radiological request. You can see, Your Honor, the report is not complete. It's not filled. It tells you
They were hiding this one.
that the process is still going on, and therefore this betraces the application by Mr. Okach to have the accused person attend to his medical treatments, so that at the end of the day, Your Honor, when you release him on Friday, we shall have a living human being to release and not a corpse.
And Your Honor, on what Mr. Omari is just about to address you on, that the accused person is an adult who should